Good morning. My name is Oliver Greenwood. I'm the president of the Contra Costa County Bar Association. On behalf of the Contra Costa County Bar Association, I'd like to welcome you to the 26th Annual MCLE Spectacular. This morning's program, I'll Die Before I Get a Divorce. What happens when a party dies while a divorce is pending, presented by the Contra Costa County Bar Association Family Law and Estate Planning and Probate sections. The materials for this presentation can be downloaded from the file above the chat. Well, it's Friday. This has been such a great event. CCCBA has done it again. After this program, I'm looking forward to hearing from Rep. Eric Swalwell. I'm sure he'll have some interesting insights for us all. Then, I plan on visiting the sponsors, so stop on by the section meeting rooms. I hope to see you there. As a reminder, if you missed any of the programs, they will be available to watch next week and on this platform until the end of the year. Our event and the program sponsors are an important part of the CCCBA community. They make it possible for us to provide events like this. So please support us by supporting them. At this time, I'd like to pass the program over to Kathryn Korn. Kathryn?
Thank you, Oliver, and welcome to everyone. Thanks for joining us today for I'll Die Before I Get a Divorce. Once again, we are going to have an intricate fact pattern. So if you would like to download the materials, please go to the File tab. It's right above the chat button, and you can download the materials there. So today we have Kimberly Kirkpatrick with the Family Law section from the law offices of Joseph Wolch, and Tracy Regli, a fellow board member on the Estate Planning and Probate section. Tracy is, of course, with Acuña Regli. So I'll turn the program over to Tracy, and she'll give us the facts for today's program. Thank you.
Hello, everyone. Thank you for having us here today. Let me tell you our fact pattern for today. Arnie, a single man, was a successful WWF wrestler. One night during a wrestling match, he was thrown out of the ring onto a table. The table was a wrestling prop that was supposed to break apart upon impact. However, due to a manufacturing defect, when the table broke, it produced a sharp edge that went through Arnie's leg, ending his wrestling career. Arnie will walk with a limp for the rest of his life. Arnie sued and was awarded a hefty $5 million settlement. Soon after his wrestling career ended, Arnie decided to run for mayor of Martinez. In 2010, during his campaign for mayor of Martinez, he met Maggie. Maggie was a wealthy socialite who donated substantial money to Arnie's campaign. She was a successful CPA and had a promising career in front of her. They instantly fell in love and were married within a few weeks on February 14, 2010. Arnie was successful in his bid for mayor. Arnie and Maggie moved into the mayor's mansion in Martinez. Arnie persuaded Maggie to give up her CPA practice and dedicate herself full-time to helping him with his mayor duties and starting a family. In 2012, Maggie gave birth to twins, a boy and a girl. She quickly realized she was going to need help with the twins with Arnie's busy schedule. They hired Nancy Nanny to help out. After starting a family, Maggie insisted on creating an estate plan. They went to see Larry Lawyer in downtown Martinez. He drafted a comprehensive estate plan for them. Each spouse was the successor trustee and primary beneficiary of the deceased spouse. Upon both their deaths, it would be split equally among their children to stay in trust until the children turned 30. During his re-election campaign in 2014, Sally came forward accusing Arnie of being the father of her one-year-old child. Arnie, of course, adamantly denied the allegation, but it was later revealed on an episode of Jerry Springer that he was the father. Sally was awarded $5,000 a month child support, payable until the child turns 18 or finishes high school, whichever is later. In a weird turn of events, Arnie's popularity with Jerry Springer's audience brought him a landslide victory in his re-election. Maggie decided to stand by him, and they continued on as mayor and first lady of Martinez. In 2019, Arnie decided he was going to run for president in the 2020 campaign. In March 2020, while attending a parade for his presidential election campaign, Arnie was injured in an accident. The driver of his float had too much to drink and ran the float off the road and down an embankment. Arnie sustained serious injuries. Arnie filed suit against the float company. While Arnie was trying to recover from his injuries, he and Maggie spent a lot of time at home. Maggie noticed that Nancy's 4-year-old son had a striking resemblance to Arnie. She bought one of those home DNA testing kits and secretly tested Nancy's son. The results came back that Arnie was the father. Maggie moved out of the house with her twins and filed for divorce on June 1st, 2020. In a preliminary order, she was awarded $5,000 a month for each child in child support. Arnie immediately went to Larry's lawyer to redo his estate plan to take off Maggie. Larry explained he had a conflict of interest and referred him to Andrea attorney. Andrea prepared a revocation of the previous trust. She also prepared a pour-over will for Arnie and a new trust. The will named Arnie's new girlfriend, Karen, as the executor. The new trust named Karen as trustee and left everything equally to his issue to stay in trust until they reached the age of 30. Andrea advised Arnie that his trust could not be funded until the divorce was final. He did not fund his trust. In August 2020, Arnie died suddenly from complications from his float accident. His lawsuit is still in progress for his injuries. Shortly after Arnie's death, Karen found out she was pregnant with his child. She is due in April 2021. Arnie spent a lot of money on his campaigns and divorce attorney. His assets at death were as follows: $2 million from his personal injury lawsuit, $2 million property acquired during marriage, $1 million in life insurance that names Maggie as the beneficiary, and $2 million possible recovery from his personal injury lawsuit from the float accident. Arnie also had debts of $500,000 mortgage on the marital home, his $5,000 per month child support for the 6-year-old at $720,000, and $10,000 per month for his twins at $1,200,000. So let's dig into this. And if this reminds you of law school, that's not an accident. All right, so Karen comes to see you for legal advice. If you will recall, Karen is the latest girlfriend. She is the one who is pregnant with Arnie's unborn child. But please keep in mind that Maggie and Arnie are not divorced yet. Their divorce was in process, and that's what brings us here today. So Karen comes to see you for the following reasons. 1, Maggie, the wife, is threatening to contest the will and the trust, and Karen serving as executor. 2, Maggie claims the will and trust were created in violation of the family law restraining orders and therefore are void. 3, Maggie claims as his wife, since the divorce was not final before his death, that she gets everything. 4, if Karen opens probate, Maggie is filing a creditor claim for $1.2 million, the $5,000 per month per child for the next 10 years until they turn 18. If Karen opens probate, Sally, the mother of the now 6-year-old, that's the one from the Jerry Springer show, if you'll remember, is also filing a creditor claim in the amount of $720,000 for her child support order. 6, Nancy claims her 4-year-old son is the biological son of Arnie, but he is not listed as the father on the birth certificate. And if you'll recall, Nancy is the nanny that Maggie found out the child was actually Arnie's from the home DNA test. 7, Karen wants to file a creditor claim on behalf of her unborn child too. And then 8, the personal injury attorney is calling Karen asking what he should do with the personal injury case. So we are going to try to get through all of these questions in the time we have allotted today. So wish us luck. Here we go. So issue 1. Maggie is contesting the will and the trust. So trust contests are guided by Probate Code section 21310. And there are various reasons to be able to contest a trust: forgery, lack of due execution, lack of capacity, menace, duress, fraud, or undue influence. And then Probate Code section 8004 and 8252 guide will contest. lack of testamentary intent or capacity, undue influence, fraud, duress, mistake, revocation. So here, you know, most of us in the estate planning and trust administration and trust litigation field, the general grounds for contesting a trust or a will is lack of capacity or undue influence. Here, we really don't have those issues. I mean, we could say that Arnie was influenced by Karen, but there's no basis in this particular fact pattern to suggest that his accident caused him to lose capacity or any of those types of things. So really what the issue here is, are the trust and will created in violation of the restraining orders that were in place when he started his divorce? And I'm going to let Kimberly talk a little bit about those facts and take it from here. Kimberly?
Thanks, Tracy. So when a party files for divorce, the court issues a case number and files their petition and issues a summons. And on the back of the summons are what we call the ATROs, or the Standard Family Law Restraining Orders. And essentially, these are orders that go into place immediately upon the party being served with the divorce papers, or the party who's filing for the divorce. As soon as they file, they're bound by the ATROs. And these are orders that are intended to maintain the status quo until the parties can get before a judicial officer or reach some kind of agreement as to how they're going to divide the marital estate. So some of the examples of ATROs would be a prohibition against removing minor children from the state of California. You're prohibited from selling or transferring or encumbering estates. Now you can still use money as you need to take care of the usual business of life, but anything out of the ordinary is prohibited. And one of the biggest ones is you're prohibited from making any changes to your insurance policies. So as I was saying, as soon as the petitioner files the petition, they are bound by the ATROs. And as soon as the respondent is served with these petition and summons, they are bound. Now those will remain in effect until the resolution of the divorce case and entry of judgment. Family Code Section 233 is going to be the statutory authority there. And the ATROs are set forth in detail at Family Code Section 2040. So whether Arnie was bound by the ATROs at the time of his death is going to depend on whether Maggie had effectuated service of the petition and summons on him. Now, I'm going to guess by our fact pattern that if we have Arnie running to see Larry Lawyer, he probably knew that the divorce was filed. So I'm going to guess that he was served. So one of the things that goes into effect with the ATROs are some limitations on estate planning. So you can't give, before there's any ATROs in place, there's still some limitations on what you can give away with respect to community property. So if you're a married person, you can't give away more than you have. So you're never going to be able to give a gift of more than half of the community property away to someone other than a surviving spouse. But once the ATROs go into effect, let's take a look at what happens. So estate planning actions are going to fall into one of four categories under the Standard Family Law Restraining Orders, or ATROs. There's those actions that are permitted, those that are permitted with notice, those that are permitted with the consent of the other party, and those that are permitted only by court order. Oops, going the wrong way here. So looking first at what actions Arnie can take that have no restrictions on them. Arnie can create, modify, or revoke a will, and he can create but not fund a new revocable or irrevocable trust. So those are the only two things that he's going to be able to do without taking something other than his own actions. Then when we look at what is permissible with prior notice to the other party, we still have the first two, which are the create, modify, or revoke a will, and create but not fund a new trust. Now we get into where it gets a little bit meatier. You can revoke a revocable trust, but you must first give notice to the other party. You must file the notice with the court and serve that notice on the other party prior to your revocation. You may eliminate a right of survivorship for property. If there's something that you hold in joint tenancy with a right of survivorship or as community property with a right of survivorship, you can eliminate that and change the property then to joint tenants in common. But again, you must file notice and serve that on the other party before the changes take effect. You may also, revoke the transfer to a beneficiary of a non-probate transfer. And Kathryn, can you give us a little information on what would be a non-probate transfer?
So in this case, you could, you are able to transfer inter vivos gift of separate property, because that would be property that the spouse owns on his or her own.
And then finally, we get to the category of permissible with prior written consent of the other party. Oops, I'm going too fast with my slides. So those things that you can do with the consent of your soon-to-be ex-spouse would be to create or modify a non-probate transfer in a matter that affects the disposition of property subject to a transfer. And you can fund the trust that you can create. So again, you can create a new revocable or non-revocable trust without notice to the other side. In order to actually fund it, then you would need to have the consent of the other party or a court order. Then we get to...
And Kimberly, just to be clear, we note that Arnie has some separate property in his assets. His original personal injury suit before he was married to Maggie. So how are those specific assets affected by the ATRO?
So if we are talking about the those two things that you can do without any written notice to the other side, that being create a new will or trust, but not fund the new trust, Arnie could create a new will that disposes of those separate property funds that he had with the original personal injury lawsuit, and anything that he can trace to those funds. So if I believe he received $5 million, let's say that he treated himself to a lovely top of the line Ferrari. If he can trace that original personal injury lawsuit settlement to the Ferrari then can be gifted to whichever one of his many, many loving children, I'm sure would love to have that.
Thank you.
All right, so then we finally get to, I just can't work these slides, permissible only with prior court order. And I'm going to start by tossing out a caveat that in family court, the court is generally going to grant any order that the parties ask the court to grant that they are in agreement with. So generally, anything that is permissible only with prior court order, if you get your soon-to-be ex to agree to it, that's pretty close to having a rubber stamp kind of a methodology here. So cashing, borrowing against, canceling, transferring, disposing of, changing the beneficiaries of any insurance or other coverage, including life, health, automobile, and disability, held for the benefit of the parties and their child or children for whom support may be ordered. This is a really long one, and this is one that actually comes up frequently in family court cases. Frequently, parties will decide that they don't want to continue to keep the other party on their auto insurance. Why that's the one they go to instead of the life insurance, which would certainly have a bigger impact, who knows? But this is definitely something that we see as practitioners quite a bit. So it's important that we remind our clients that the ATROs are there as actual court orders and not just an invitation to read a little something. And so again, if we look back to what's permissible here under Family Code 2040, subsection A3, any changes that you want to make to your life insurance beneficiary, any changes that you want to do to disability insurance, anything of that nature, you're going to need the consent of the other party, or you're going to need good cause to do so and have the court grant that order. And I do want to point out that funding or creating a non-probate transfer if the other spouse does not consent is something where you probably really would need to convince the judge that there's good cause to do so. Because again, if the spouse is not consenting, you're relying only on the judge to give you permission to take that action.
So in other words, if Arnie wanted to say, purchase property with his new found love, Karen, and he was using his separate property to do that, that would be a permissible non-probate transfer, because that is something that would pass outside of probate were Arnie to die. But he could not use community funds in any way, shape, his half of community funds to make that purchase, correct?
Well, that is an interesting one. If I were advising Arnie, I would be very careful about allowing that transaction because although it is separate property, the entirety of an estate, including both separate and community property, comes into play when we're looking at attorney fee awards as well as spousal support. So even though we have we can revoke a transfer of the transfer to a beneficiary of a non-probate transfer if we do prior notice to the other side. Going out and purchasing something, even if it is with separate property, is going to take us back to that very first ATRO, which is prohibiting anyone from buying or selling outside of the usual custom. So I suppose if Arnie had a business where he was buying and selling property, that might be something that would be a normal course of business, but for most people that isn't going to be a normal course of business. So the takeaway message being, if you are a family law practitioner and you're wondering if something is permitted under a non-probate transfer, you want to call Kathryn or Tracy and double check as to exactly what the transaction is. And make sure that you're not sending your client down a bad path that's going to come back to bite them. And here we have a little bit more with respect to what a non-probate transfer is. So I will let Kathryn, if you would like to speak on that just a little bit there.
So basically, assets are subject to some sort of formal transfer upon death. And either they will be transferred through the medium of a trust or perhaps through an actual probate proceeding, or in the case of life insurance, who is the beneficiary designated on that insurance plan? Is there some type of retirement account with a beneficiary designation? Or is there simply an account at a bank that says payable on death, POD, or FBO for the benefit of someone? So these are other ways the property could be transferred at death, not going without going through a formal court proceeding.
And again, back to Family Code 2040, subsection A and number 4, you would need the permission of a prior court order before you were making funding or creating any of those kinds of transfers. So that again takes us back to no changes to life insurance, no changes to beneficiaries. Essentially, those ATROs are just going to want to keep everything status quo until the divorce judgment is entered. So that takes us then to what happens when Maggie says, I'm the wife, divorce isn't final, I get everything. So with respect to Maggie's claim, Maggie's correct in that she is still his wife and she will remain his wife until judgment is entered or a bifurcated judgment that is dissolving the party's status only is entered. And if she is still legally his wife, what will we need to have her be able to claim the entirety of the estate? Well, I suppose we would have to either go back to the original estate plan that Maggie and Arnie went to do upon the birth of their children. And if the estate plan that Karen and Arnie did together, or I guess Arnie did for the benefit of Karen, if that estate plan were to be found invalid, Kathryn, would Maggie then still be entitled to take under the first set of estate plans?
So if Maggie and Arnie are still in fact married, and the first trust has been unfunded, Maggie could still take as the surviving spouse, but there are children. So Maggie would not take the entirety of any estate. She would have to share that with the children. And Tracy may want to speak to all of the loving children because there are quite a few.
Sure. So skipping ahead to issue 3, does Maggie get everything as his wife? There is one scenario in which she would get everything. That scenario would be that Arnie's new trust and his new will that he created subsequent to the filing of the divorce are deemed invalid, and the trust that he created with her before their divorce is valid because that trust did in fact give her everything. However, for the purposes of our fact pattern here, although it did not explicitly state, because no good law school exam ever explicitly states anything, I think that we can assume that Andrea attorney was a very wise attorney who understood. She told him not to fund his new trust, which was good legal advice, and that she knew that in order to revoke his previous trust and will, she would need to provide notice. So I think we can safely assume here that she did in fact provide notice to Maggie. And even though she didn't like it, she didn't jump up and down at the time because she was done with Arnie and she was divorcing him and she didn't know he was going to die. Now, so if we take that trust out of the equation, which we're going to do, can you advance the slides just a couple for me, please? Couple more.
I'm sorry, back? Here we go.
No, forward to about slide 16. That it says issue 3, does Maggie get everything as his wife?
There we go.
So we know that Arnie can create a will without any notice, and he can create a trust as long as he doesn't fund it, and he did not fund his trust. So at the very least, I think we can assume that the will is valid. The will, although most likely a pour-over will because he has a trust, they often have a provision that says, if for some reason the trust fails, I still want everything to pass as if the trust were valid, but now it's going to be a testamentary trust. So I think at the very least, we can assume the will is valid. It names Karen as the executor, and it either pours everything into the trust, which leaves everything to his issue, or in the alternative, a testamentary trust would probably be created that would leave everything to his children as well. So there's really not a scenario where Maggie gets everything. Even if Arnie died intestate, meaning without a will or a trust, somehow all of the documents failed for whatever reason, as Kathryn was pointing out, we have separate property and we have community property. So a surviving spouse does get the share of the community property by intestate succession. But here, where there's so many issues, Maggie, as the surviving spouse, would be entitled to 1/3 of the separate property, and his children would be entitled to 2/3 of the separate property. So no, Maggie's claim that she gets everything as the wife is not likely to stand, and Karen likely will be executor. And won't that be fun for them?
And we thought we had all the fun in family court. I do want to take just a moment to note that we don't see quite as many cases for legal separation as we used to. The reasons that people would choose a judgment of legal separation are to some extent, those have been eliminated by insurance companies and that type of a thing. But if you are dealing with someone who has pursued a legal judgment of legal separation, that gives us an interesting wrinkle. Because while a judgment of legal separation does not terminate the party's marital status, it does terminate the consideration of the surviving spouse as a surviving spouse for purposes of intestate succession. So if you are meeting with someone, working with someone who is interested in a legal separation, you want to make sure that they understand that they will not keep the right to inherit in the event that someone were to die without a will. That's not one of the things that would be protected by a judgment of legal separation. And what about a nullity? So an action for nullity, if there's an action for nullity that's pending, that does survive the death of the parties. The nullity is something that is essentially a type of a fraud case that's specific to family law. And so the ongoing action asking the courts for a finding of nullity and a judgment of nullity, that would be a claim that would continue on, and the person who has died, their estate could continue to pursue a grounds to pursue a finding of nullity, and that would have certainly impact on the community property that would be in the estate. If there's a judgment of nullity, then the community property would not exist. It is essentially a judgment that the marriage never happened. And again, going backwards here. All right. Okay, so now that we are looking at the divorce process, the important thing to note is that it doesn't seem from our fact pattern that much had happened with respect to the divorce action other than the child support order. But if the family court had adjudicated any issues prior to Arnie's death, those orders would stand. So if the parties bifurcated, for example, the status of the marital home, or if they bifurcated who was going to maintain payments on Arnie's collection of priceless wrestling action figures, those kinds of things would be things that if the court had made a decision about any of those, that is something that would stand. And of course, spousal support by definition is terminates upon the death of the party, and any spousal support that had been paid prior to death would remain as an obligation that had already been met. So you're not going to have there's no payment back from the estate of spousal support already paid, but it does terminate as to any support from the date of death forward. But child support, not so much. So let's talk about that some more as we move forward. And with respect to matters under submission, as we all know, the court doesn't always move as quickly as we would like. And sometimes we have a trial with a bench officer, and they have a statutory period in which to render their decision. If a matter has been submitted to the court for judicial decision, but the decision has not been announced at the time of the party's death, the estate would be bound by that decision when it is issued. So again, if you're in that waiting period between your trial has ended, the attorneys have all said matter submitted, and we're waiting for the judicial decision, that judicial decision will be valid once it is announced. All right. So as Tracy was saying, Maggie is not likely to prevail under any theory that she is, as Arnie's wife, gets to take everything. But do keep in mind that any community property that was acquired regardless of what Arnie has done with his will, she still is entitled to her half of the community property. But of course, once we have the matter in probate court, it would be the probate court and not the family court that was making the determination of which assets and funds are community versus separate.
So Kimberly, just to jump in really quick before we move on to that, that is, if you have a situation like this, which is not completely uncommon, if you can work with whoever is counsel for Maggie and as counsel for Karen, I mean, there's not a scenario in which these two women are likely to work cooperatively together. So here it might be really helpful to bring in a neutral third party to serve as the executor, because Karen would have complete control of the estate as executor, but Maggie is not relinquishing her control over her one half of the community property. So the two of them would absolutely have to work together to sell property, to pay bills for property. And if they can't do that, this estate administration is going to be difficult at best. So just something to think about as a practical matter.
Okay, so now comes the big fun. When we go back and look at that family tree with all of those kids that are Arnies and kids that might be Arnies and babies that haven't been born yet. Tracy, will you talk a little bit about what happens when we have a parent who dies and there are still minor children that are running around needing their Twinkies and Cheerios?
Sure. So as you had mentioned, Kimberly, child support does not subside on the death of the supporting parent. It is an obligation that survives death, and it actually can be filed as a creditor claim against the estate for the remainder that is due of that obligation, depending on what the order says, 18, or perhaps until the child turns, or the child graduates high school. Whatever that order is, you can calculate that out. And something that administrators need to be aware of is you do need to pay the child support ongoing in an administration. So be aware of that. If a claim is filed for monthly payments, you may need to continue to pay those even though the claim has not been completely settled yet. Kathryn, would you like to talk a little bit more about this?
So the interesting fact, or part of our fact pattern here too, is Arnie has about $1,920,000 in future creditors' claims for 3 of the children. Nancy, who has a 4-year-old with a birth certificate that does not list Arnie as the father, may try to present a claim in court for some sort of future support. However, it is highly unlikely, and we will discuss further, that that claim would be successful. Then we have an unborn child of Karen's who may likely have a claim, which Kimberly will address in a moment. But the creditors, any creditor of a decedent has to comply with certain time requirements, and they're very, very important. You have to file a claim within 4 months from the date that the probate person is declared by the court to be the executor or a special administrator of the estate. If that claim is rejected, then the creditor must follow up within 90 days with a suit. Must. There are certain statutes of limitations regarding these claims, and under limited circumstances, a creditor may sometimes file a late claim, but it's a very difficult undertaking. Actions against decedents in general commence it within 1 year after the date of death. But again, if you're trying to, let's say Karen said, Arnie promised me something from his estate, those must be advanced 1 year drop dead date. You're not going to come in several years later and say, gee, shucks, you know, should have done that. Sorry, I didn't do it. It will not be. You will be barred and prohibited from doing that. I think this may be, and I'm sure if we go to our next, nope. Well, let's go back to the obligation, Kimberly, of who's going to make payments for what children.
Okay, so if I don't know that we necessarily have a slide for that, but what we have is a total of $1,920,000 in child support claims. And when we look at our family tree and our fact pattern, we have Maggie, who has a child support order. We have Sally, who has a child support order. We have Nancy, who not only doesn't have a child support order, she doesn't have a paternity determination. And then we have Karen, who has an unborn child. So we have, as compared to each other, we've got moms who have child support orders, and we have moms that don't have child support orders. And then we have a mom who might not actually be looking at the right baby daddy.
So moving on with our creditors' claims, how would Karen advance a claim? Because she is the person with whom we have no idea with any certainty who the father is.
So a child support action can be filed while a woman is pregnant. What happens is that we have, excuse me here. So a child support case can be opened while a woman is pregnant. And what happens is that the court will stay the action until the baby is born. The court does not have the authority to order in utero DNA testing. DNA testing is going to be required if the father is not consenting to paternity. And obviously, if Arnie is dead, he can't be consenting that the child is in fact his. So everything is going to be put on hold from respect to the child support filing until Karen gives birth. And then once the baby is born, she then can have the baby tested. But we run into a couple of issues. First of all, what happens to the probate matter while we are waiting for the baby to finish growing and be born? Is the probate matter also stayed? And Tracy or Kathryn, maybe you can speak to that.
So there would really be no way to effectively close out the probate, because once we do that and we've distributed everything, the likelihood of getting 1 cent back, should there be an award after the probate is closed, is slim to none. So for all intents and purposes, we would need to leave it open. However, given the time period, it's not that unusual that a probate would be open for that length of time anyways. I mean, most probates, especially when complicated with separate property and community property and this many children and so on and so forth, would likely last a year to 18 months anyway. So I don't think it would it would prevent us from closing, but it wouldn't be out of the norm for the probate to last that long anyway. So I don't think it would be a detriment or slow it down more than.
So for a practical matter, it's unlikely that a pregnancy would have much of an impact on the probate case. But how do we test Arnie if he is no longer with us? And what happens if Arnie's family decided that they were going to have Arnie cremated? What experiences can you guys share with respect to DNA testing of someone who has left us in this state?
So one option on the DNA testing would be to look to other family members were Arnie to have been cremated. That would be a possibility. I think that the other issue with regard to, if I could just step back to the length of a probate, we have to remember that it may well be that Arnie had passed away from the float accident, which would be another reason you would have to keep the probate open, because that's going to be part, if there is any settlement, potentially you'd have to have the estate representative working and handling that portion of the claim in the probate. But DNA, if he's cremated, could be a dicey. Kimberly, do you have any experience with moving to family members if the decedent is no longer available?
You know, Kathryn, I don't, because my practice typically involves child support orders. The DNA requirements to establish paternity for a child support case they're pretty much going to always be based on a parent being alive, because you can't get that child support case child support order from someone who has already died. You're then going to be, if you're the parent and if you have the child support order before death, we know that continues as a creditor's claim. If we don't have a child support order, we know that there is an obligation against the estate of the decedent to continue to support his minor children. So I think we would, number one, be again relying on the fact that the probate court is a court of equity, and hoping that the court would look to some reasonable method of establishing paternity, such as DNA testing of very close relatives. We certainly have plenty of siblings that we could look to for testing. But outside of marriage, where we have some paternity presumptions, we're always going to have a couple of things that are going to happen every time we have DNA testing. Number one, it's going to be through the court. So we would not have Sally being able to come into court with her paternity test from Jerry Springer. That isn't going to be sufficient. We know that she got a child support order, so that tells us that at some point in the process, there was a court-ordered DNA test that was done through a qualified lab, and it met the required number of indicators and the required percentages. Now with Nancy, although we don't know if Nancy knows that Maggie did a little home DNA test, that home DNA test isn't going to stand either. So there's a problem for Nancy with respect to DNA testing. And of course, if she's looking at bringing a cause within the probate case, we would be back to that same trying to establish that there was, with enough certainty, that there was enough of a genetic connection to consider it a father-child relationship. Now, Karen being pregnant, if Karen had managed to, if Arnie and Maggie had done a bifurcated judgment that would terminate their marital status, and the most recent, or the most frequent reason people do that is because they have a new spouse to be waiting in the wings. If that would have been the process, and Karen was married to Arnie at the time of his death, and she's pregnant, there are some presumptions that would kick in. And as someone who is married and pregnant at the time that Arnie died, the first presumption would be that Arnie was the father. So definitely some interesting DNA twists come up when we start talking about determining parentage after someone has passed away.
So going back to the creditor's claim, I think what we're saying is, yes, of course, because we have the child support orders, those are creditors' claims that an estate administrator can look at and can agree with, and agree to have the estate going forward pay for those. But in the case of, let's say, Nancy, the nanny, she has no underlying claim. She has nothing. So the issue becomes for her, does she even file something? Because she doesn't really have an underlying claim. She could try to file something. It would then have to be adjudicated, and the probate would, of course, remain open during that period of time. Likewise, Karen, I think, same thing. There is no claim as yet for an administrator to either allow or reject. So this is going to be one long probate administration.
I think that brings up a good point. Is it possible, let's just say for the sake of argument, that there was no dispute about Karen's child, everyone agreed it was Arnie's for whatever reason, but he's still gone before that child was born and she has no child support order. Is it possible to go to family court after somebody dies and get a brand new child support order, or has that ship essentially sailed?
That ship has sailed. So child support in California is based on a mathematical equation. And one component of that equation is the timeshare that each parent has with the child. And another component of that equation is the income that both parents are earning. So we don't normally look to assets as a means of payment of child support. Now, there are some exceptions if someone doesn't need to work, so they have no income, but they have a very large estate. We might look at a reasonable rate of expected return on the type of assets that they have. But I think really in this kind of scenario, both Karen and Nancy would really be relying on a claim against the estate. But it wouldn't take the support, it wouldn't take the place of or the form of a creditor's claim like an existing child support order would. And a question for either of you that came to me as we have been working on this presentation: when you have these very large child support creditor claims, is there any discount to present value when the court is actually writing out the checks as the estate is closing?
Tracy, did you want to leap in, or?
Sure. So I've only had this come up a couple of times in my practice, and in all honesty, we're going to get to a slide a little bit later in the presentation that talks about the inequity here, where you have children that have actual child support orders and children that don't. So in the couple of times that I have had it, the one, we just simply paid it because there were no other children that would have been treated unequally. And in the other instance where I had it, we actually reached a settlement through mediation because the result, if we would have paid them, would have been so inequitable to the children without child support orders that we felt a settlement had to be reached. So I've never seen it through to completion, so I don't know that there is any present value discount. I've never had it actually come up and had to test it.
I think one option would be to look into other avenues for future funding. So perhaps buying an annuity or something now, or I don't know if there was, we only know in this instance that there was a life insurance policy, but that's payable to Maggie, and certainly that is a non-probate transfer that is going straight to Maggie. So it's not going to impact necessarily the, the settlement, or for the, 1.2 million for the twins.
Right.
I think another thing to look at here, and Kimberly, you may know the answer, do we ever use insurance policies to fund future financial responsibilities in a divorce? So that's an option.
We typically see insurance policies as security for child support, or even spousal support, or equalization payments that are going to be made in installments. We see that more frequently for estates that wouldn't have assets to cover the total of the obligation. but it is something that's frequently negotiated in divorces, and it is something that the court does have the authority to order life insurance to be maintained as a method of ensuring that child support is in place until the child is emancipated.
So this actually leads us right into our next slide, which is, did Arnie provide for his children another way such that the child support orders were taken care of? And there's some really good case law on this, where a testator makes a will that gives money to his children or leaves things equally to his children. It can, in fact, take care of the child support order. And courts have found that the father has then provided for his children, and it's basically they inherit through the will and not through the creditor claim. And we're going to talk about some significant differences in a moment. But same with the trust. Here he had a trust that provided for his issue. Yes, we have some questions about who exactly is his issue, but he provided equally for them. So both case law for the will and the trust suggests that actually the creditor claims could be disregarded and the children could inherit from the will or the trust. Now, if we had an intestate scenario, it does become different, because there he has not provided for them another way. And as we have talked about, he does have a wife. So it's not even as if the children are inheriting equally. He has a wife that is going to inherit something, potentially 1/3 of his separate property and all of the community property. So that is something to keep in mind. But certainly if the court were to go that way, it would treat his children more equally, but something to keep in mind. So if the mothers of the children were to get their creditor claims paid, that goes to them. There is no further court supervision of that money. They are free to use that for their children. Essentially, we like to think they're using it for their children, but they're free to use it for whatever. There is no further court supervision of that money. However, all of the children that we're talking about here that would inherit from Arnie are minors. And most likely you would need to have a guardian of the estate set up for these minors, and that money would need to flow into that guardianship estate, which would be subject to court supervision until they turn 18. And so whoever is the guardian, presumably the mother, would have to report to the court. They would have to basically survive scrutiny of the expenses that they were making, where they don't have to do that with the child support order. So something to be aware of there.
And I think there are plenty of child support payors that would really prefer that there was some scrutiny over the spending, but I guess that's a legislative intent issue for another day.
And just to circle back to Tracy's comments earlier on, recall that if the will incorporates that trust by reference, in other words, if the trust failed, if everything went out the window, but the will says, if that happens, I want a testamentary trust in place, meaning then in the probate action, they will establish the trust, and the issue would be, if the issue are to be treated equally, the issue would be taken care of. So an option there would be, if there was not a settlement and the money went outright to the mother, there very well could be, by the terms of the trust, trusts for all the minor children.
Speaking of all the minor children, let's take a look at Nancy's son. So Nancy's got a very complicated situation, because all we know is that Arnie is not listed on the birth certificate as the child's father. And we know that Maggie did a little home DNA test and found out that the home DNA test said, yeah, he's the daddy. But we don't have in California any statute of limitations for determination of biological paternity. But one thing that we do have is a statute of limitations for challenging presumed parentage. So our fact pattern doesn't tell us whether Nancy Nanny was in fact married while she was working as a nanny. So California still has some existing statutes that do presume that a child who's born within marriage is in fact the biological offspring of the two married people. So there is an ability for either the presumed father or the alleged biological father to challenge the presumed parentage statutes, but that has a statute of limitations on it. So with respect to anyone who is coming forward at the time of a death and claiming that there's a paternity between a child and the decedent, one of the things that you're going to want to look at is making sure that there isn't a presumed father that's already been established by operation of law. So again, in order to really address Nancy's situation, we would need to know if she had in fact been married at the time, because if the child is 4, she's going to be past the the statute of limitations for challenging her husband as the father. But if she wasn't married, we're back to California having no statute of limitations for determining biological paternity, and we would then be in a situation where Nancy could potentially have a claim, not as a creditor's claim, as we've discussed, because she didn't have a child support order in place at the time that Arnie died, but she could potentially have a claim as on behalf of her child, her 4-year-old child, if in fact Arnie is the biological father. And so here's the a little bit more on the presumed parentage statute. So what's important to know is that the presumed parent is going to have rights as the spouse of the person who gave birth to the child. And even if they know that they're not the biological parent of the child, they can exert rights within the statutory time period. They can exert rights, and as long as they're not challenged within that statutory time period of 2 years, there is no undoing that presumed parentage. I would say finding, but it really is just an assumption that happens by operation of law. And so then we've already touched on DNA testing and the difficulty of dealing with someone who's been cremated, or as Kathryn had mentioned, not today, but the court really doesn't like to dig up dead bodies. So the Family Code Section 7555 is going to set forth the degree of certainty that's required for genetic testing for child support purposes. But again, as a court of equity, we would expect that the probate court would be more open to an indirect DNA testing conclusion through family members and that type of a thing. All right, so now we start getting into equitable arguments. So California public policy still favors finding that if the state has the choice of declaring a father to be the spouse of the mother or to be someone else, public policy still favors finding that it is in fact the spouse that is the parent. So we also have hand in hand with that children who are born of marriage are less likely to have a court order for child support than a child born outside of marriage. And think of it this way. If you have a husband and wife, they get married, they have a child, they get divorced, we now have a child support order for that child. Then let's say that husband remarries and wife number 2 and husband have children together, and there's still an intact family when the husband dies. We have 2 women who were both married to the decedent. They both had children with the decedent, but they are very differently situated with respect to their ability to make claims at the time of the father's death. And Tracy, I think you've got the next slide as we start to talk about the differences between, oops, here we go.
Here we go. So this slide illustrates a case actually that Kimberly and I had where, so for purposes, Arnie's estate has roughly $2.7 million. He has created estate planning documents that say he wants to leave his estate to his issue, possibly 5 children. We're not sure how many he had in mind when he created it. So if we take 1.9 million off the top for the creditor's claim, which are the child support orders that are in effect, then you have $830,000 left for distribution. So you can see that twin 1 and twin 2, which each have a child support order in effect for $5,000 per month, they each get $600,000 from their creditor claim, or to state it more succinctly, actually, their mother gets $600,000 for each creditor claim. And then they potentially have $166,000 in a guardianship, which would get eaten away, a lot of it with court fees, to be perfectly honest, because $166,000 for such young children is not really that much to last the remainder of their life until they turn 18. In fact, probably wouldn't even pay for their college education these days, but that's beside the point. So then we have the 6-year-old who also has a creditor claim of $720,000. And they too would get $166,000 in the estate, probably into a guardianship, most likely. So now you can see each twin's net is $766, and the 6-year-old gets $886, and then the poor 4-year-old and the unborn child get $166, and they're the youngest of them all. If anything, they would likely need more money, not less. So you can see how unequitable it can be. And in the case that Kimberly and I had, it was a similar result where one child was going to be substantially provided for, both through the creditor claim and the inheritance, and the other 2 children that did not have child support orders because that relationship was still intact, were going to receive substantially less. Now, I will tell you that I don't know what the result would be. We like to think that the probate court is equitable and would somehow change it. But Kimberly and I both searched and searched, and we could not find any case law, any statute, anything that provided any guidance. And it's a pretty scary proposition when you're looking at little children and gambling with their future. Ultimately, the mother in that case decided to settle with the other mother. Granted, the other mother did get quite a bit of her creditor claim paid, but not the entire thing. But again, when you're risking your children's future, that's a pretty scary endeavor. I would love to have known how that case turned out, but not had to risk children's lives to do it. But something to be aware of.
And in dealing with these claims within the context of a probate, Tracy had earlier mentioned maybe a neutral would be a much better choice to serve as the executor instead of, in this case, Karen, the last girlfriend. Another option may be early on as attorneys to suggest submitting to a mediator, having your case looked at. Sometimes clients don't want to hear it from you. They want you to just fight for them. Sometimes if they're listening to a retired judge and an experienced mediator, they might be able to hear that their case isn't as great as they think it is, and that it is more likely than not that they're going to have to settle and perhaps give up some things. So I take Tracy's point and as being extremely important, because you can eat up a lot of fees in a case like this, and they do happen.
And piggybacking on Kathryn's comments, I really think in the case that Tracy and I had, it was sort of an offhand comment that the family court judge made during a status conference that was probably the turning point that got everyone to the table as far as trying to work out a settlement. So I would like to think that if we had been forced to go to trial, that the equitable powers that both the family court and the probate court have would be put to good use in making sure that children, minor children, are all equally provided for in a fair manner. And I think that the family court didn't have they wouldn't have had the authority to make any rulings in this case. But I did find it helpful, and also it certainly seemed a bright spot in a difficult case to hear the family law court comment that they would expect that there'd be some sort of equitable outcome. So although we did not see how the court actually would have addressed the issue, I did think that was a positive spot of hope that we saw as we came out of that.
And yet we still have one more court proceeding to potentially deal with in our fact scenario. And that is, did the float or does the float accident survive Arnie's death? So in looking at that potential suit, recall from law school that all of Arnie's pain and suffering, all of the general damages involved or connected to the float accident die with Arnie. So that would be his separate property. Were there to be a claim, it's all terminated at Arnie's death. However, economic loss claims could survive Arnie's death if the heirs band together and they file a common law survival action. And that's as opposed to filing a wrongful death case. So with a common law survival action, there are more remedies available for these heirs. And the initial question that I would ask Kimberly would be, would Maggie be an heir? Would she be considered to be an heir as a still undivorced?
She still
She's
is
in there.
A surviving spouse. So
absolutely.
Whatever the surviving spouse gets, I'm sure Maggie will be standing in line to get her due
properly
share.
So. Yes, and Karen's unborn child, likewise, I believe would be considered to be a part of this action. Now, under the common law survival action, and in our facts that were given to us today, if the heirs file it, but they continue to fight, the trier of fact is going to make the ultimate allocation of recovery, to the individual parties. So it would either be in the context of a jury trial or if it's just in front of a judge. And more than likely, all of the assets or all of the things that might have been awarded in the probate action will likely be considered. Likewise, this is a part of the fact-based scenario where that inequity that we saw in the previous slide could be addressed. We just don't know how it would play out. And so I don't know if Tracy, Kimberly, do you have anything else to add to our presentation? I think we're just about out of time.
I think that what I would add is that when you have a client who comes in and you are a family law practitioner, the limitations on what they can do with their estate planning are fairly important, because a divorce can stretch on for a couple of years, and you probably would be really upset to be 2 years into a divorce, die, and then find out that the person you were desperately trying to get away from actually inherited everything because you didn't revoke a prior will. So I think that's an important conversation to have with clients. We don't plan on necessarily dying while a divorce is pending, but it does happen. Tracy and I have another case that is touching both of our offices, where someone died with a divorce action pending. So it does happen, and we need to be aware of that. And I would also say, if you think that family law's got a lot of drama, I certainly have learned from you two ladies that there's no shortage of it in probate law either.
Tracy, do you have anything that you'd like to add?
Just conversely to what Kimberly was saying, if you have person come into your office who's a surviving spouse or a child of somebody who's died, who's in the midst of divorce, don't just automatically assume that you know what's going on here, because here you might have automatically thought, oh, he created a new will and trust, they're out. No, there are circumstances where they can do that. So just consult with a family law attorney if you need to, but just make sure you're looking at all of the facts and circumstances surrounding the case.
And perhaps the best thing you can do is don't be afraid to pick up the phone and contact that family law attorney.
Or the probate attorney.
Thank you very much. And I'm going to turn the program back over to Ann Wolch.
Hi, everyone. I am Ann Wolch. I am the Education Events Director for the Contra Costa Bar Association. And on behalf of the Bar Association, I want to thank Tracy and Kathryn and Kim for an amazing presentation. I'm still trying to figure out who's on first. That's as far as I got. So I want you to know that you are now all invited to join them for a live Q&A discussion immediately following my announcements. Below the screen that you are watching this presentation on is a link that will take you directly to that Q&A session. The materials and evaluation forms for this program can be downloaded from the session page that you're on right now. Just go to the File tab above the chat, and the completed evaluation forms can be sent back to me at the bar. Your attendance certificates will be available soon. If you are a CCCBA member, your attendance certificate will be on our website in your member profile. If you are a non-member or would like more information on how to get your attendance certificate, check out the FAQ tabs. Coming up after the break is our last MCLE for this spectacular year. It will be our keynote with Congressman Eric Swalwell, who will take us to 2021 and beyond as he looks at the latest on the 2020 election, resulting impact on Congress and the courts, and more. This afternoon, you can also visit the networking rooms and attend our wellness forum. I don't know about you, but I'd like to have 20 minutes of mindfulness meditation. It's been a great few days, but need to do some relaxing before the weekend. And I also want to thank everyone for joining us this year to elect to learn online with us. It's been an adventure, and we hope it's been a good one for everybody. But I hope we can get back to everybody's favorite bacon and brownies, Kim, next year in 2021 at the Marriott. So right now, I will go ahead and click on the link below and join the live Q&A session with Kathryn, Kim, and Tracy. I'll see you there.
Thank you.